How do you set up a third-party special needs trust? Have you ever wondered how to provide financial support for a loved one with disabilities without jeopardizing their government benefits? A third-party special needs trust is a great solution. Let's break down how to set one up in a straightforward way. First, it is essential to engage an attorney who specializes in special needs and estate law. This professional will ensure the trust complies with legal requirements, helping to preserve eligibility for supplemental security, income, and Medicaid. They will draft a trust document that reflects the needs of the beneficiary and the intentions of the person creating the trust. Next, the trust document must clearly state that it is for the benefit of the disabled individual. It should specify that the beneficiary cannot control or revoke the trust. This is important because it helps ensure that the trust assets do not count as the beneficiary's personal resources under the rules of supplemental security, income, and Medicaid. Now, let's talk about funding the trust. The trust should be funded with assets belonging to someone other than the beneficiary. This could be gifts, inheritances, or proceeds from life insurance policies from family members, such as parents or grandparents. Remember, assets that the beneficiary owns cannot be placed into a third-party special needs trust. After that, you will need to appoint a trustee. This person will manage the trust assets and make distributions for the beneficiary's supplemental needs. These needs can include education, medical care not covered by Medicaid, personal care, and recreational activities. The trustee must act in the best interest of the beneficiary and ensure that distributions do not interfere with government benefits. Once the trust document is executed, the next step is to transfer the designated assets into the trust. Proper documentation and titling are necessary to confirm that the assets are legally owned by the trust. Maintaining compliance with government benefit rules is vital. The trust must be irrevocable, meaning it cannot be changed or canceled. Distributions should be managed carefully to supplement, not replace, government benefits. The trust should not cover basic needs like food or shelter, as this could disqualify the beneficiary from receiving supplemental security income or Medicaid. Lastly, it is important to plan for remainder beneficiaries. Unlike first-party special needs trusts, third-party special needs trusts do not requiring Medicaid reimbursement after the beneficiary passes away. The trust document should name individuals who will receive any remaining assets after the beneficiary's death. In practical terms, setting up a third-party special needs trust involves legal drafting, funding with non-beneficiary assets, appointing a responsible trustee, and ongoing administration. This type of trust can provide long-term financial security for a disabled loved one while ensuring they retain access to essential government assistance.